Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Pine Rivers Magistrates Court. Client was charged with mid-range drink driving. The mid-range bracket starts at 0.1, goes to 0.149. My client blew literally 0.149. That's important in this instance, in the sense that high range starts at 0.15. If someone blows high range, they're not eligible to apply for a DUI drink driving work licence. But if someone blows low or mid-range, they are. So again, mid-range is 0.1 to 0.149. My client blew 0.149, and because he blew 0.149, he did, albeit only really by a very slight margin, stay within the mid-range bracket. That made him eligible to apply for a DUI drink driving work licence. So again, 0.15 is the cutoff. That's high range, no work licence. 0.149 is the top of the mid-range bracket, and even though you're almost high range by literally 0.001 of a margin, he is still technically eligible to apply for a DUI drink driving work licence, and that's what I was engaged to do for him today. When a person's mid-range, the worst case scenario is a 12-month loss of licence, mandatory minimum 1 month, but when you apply for a DUI drink driving work licence, the magistrate's got the power to double what that otherwise gives. So what would have been a maximum 12 months becomes a maximum 2 years, and what would have been a mandatory minimum 3 months becomes a mandatory minimum 6 months when you apply for a DUI drink driving work licence. But obviously the difference being, if you've got a work licence, you can keep driving for work purposes, as opposed to not having a work licence and not being able to drive for any reason. So again, worst case without a work licence 12 months, best case 3 months, and worst case with a work licence 2 years, mandatory minimum 6 months. But again, mid-range starts at 0.1, so you're not going to get the mandatory minimum when you're that far past the bottom end starting point of 0.1. And as I said, given high range starts at 0.15 and the mandatory minimum disqualification for high range is 6 months, if you blow 0.149, it's going to be almost impossible to convince a magistrate to give any less than 6 months without a work licence, and by default 12 months with. Basically, he was a carpenter, so I had to draft about a 8-page affidavit up for him to sign, talking about what he does, why he needs his licence to do it, the difficulties he's going to suffer while he's off the road, and by difficulties, obviously he's going to lose his job, lose his income, lose his ability to pay his way through life. I had to do about a 4-page affidavit up for his boss to sign, again saying what he does, why he needs his licence to do it, and that he will lose his job if he loses his licence. I asked my client to attend a reformatory course exposing him to what can happen when you're on the road with a blood alcohol concentration of 0.149. Got him to obtain some references based on a template we give all of our clients, addressing the authors as to who they need to be addressed to and the key points they've got to cover. I drafted all these documents before court, provided them to the court in advance. I met with my client this morning. We grabbed a conference room, ran through the procedure, what he can expect when we go in there, what I'm going to say, what the prosecutor and magistrate would most likely say, or the lines along which he can expect him to speak. Ran through it all, made sure it was all crystal clear in his mind. We went in. I relied heavily upon the affidavits. Like 70% of the work is in getting the affidavits right. So there's no point going to court and beating your chest and putting on a big show if your affidavits are as useful as a shopping list. Again, 70% of the time and effort's put into getting the affidavits correct and bulletproof. So I relied heavily upon the contents of those affidavits. Again, there's the magistrate, the court cannot listen to anything that you want to say unless you've already addressed it in the affidavits. There's no point raising fresh information that's not contained within the affidavit. It must be in the affidavits. As I said, the bulk of the work was already done in drafting the affidavits, but that said, I did need to verbally guide the magistrate to the appropriate paragraphs and then sort of speak on my feet, but not going outside of what was already addressed, simply elaborating on it. I didn't make any submissions on the length of the disqualification, given that he was lucky to be making the application. When your reading's that high and when you're that close to the work licence cut-off, you're really trying to have your cake and eat it too if you go making any kind of demands about the length of the disqualification. So my job today was simply trying to get the work licence over the line, and I literally said to the magistrate, I'm in your hands with regard to the length of the disqualification, which was basically code for I don't care how long it is as long as he gets his work licence. And the client was well and truly on board with that before we went in. There was no point in me beating my chest and getting the disqualification down lower by a month or something like that, only to have the application fail because I was trying to get greedy. My job was to get that work licence and by default get a moderate disqualification. At the end of the day, if you can still keep driving for work and still keep putting food on the table, really, when you've been driving around at 0.149, beggars cannot be choosers. And anyway, short version is I was successful in persuading the magistrate to grant the application, so my client was permitted to keep driving for work purposes only 6 days a week, 5 a.m. to 7 p.m, so that he can get to his job sites, keep his income flowing in. He got a 12-month disqualification, which, as I said, given his reading and given that it gets doubled with a work licence, is more than reasonable. But again, I wasn't going to make any efforts to push that down, given that it's basically a moot point. If he can keep, for work purposes, it's literally as if he hasn't lost his licence. So what does it matter whether or not he gets to drive to his girlfriend's place for 1 month less than he would have otherwise done had I not made verbal submissions? And again, he may very well have been able to drive to his girlfriend's place, but not for work, because the work licence may have failed on the grounds of the submissions being unreasonable. But again, work licence granted, 12-month disqualification, modest fine, client's clearly relieved and very happy. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road.